In this subunit, we're going to begin our discussion of interpretation of a contract using extrinsic evidence by talking about the plain meaning rule. All right, let's refresh our memories. Remember, we've already talked about how a judge will construe a contract when the parties have differing interpretations, but they don't use any extrinsic evidence to support those considerations. Effectively, the parties are arguing that this is the language of the contract, and I am reasonable in believing that it has this meaning, the meaning that I propose. And the other party says, no, you're not reasonable in understanding it that way. My interpretation is reasonable. It'll go to the judge. The judge will construe the contract based on those maxims that we've already discussed, and the judge will construe the contract in favor of one party or the other party. When we have extrinsic evidence, on the other hand, the matter goes to the jury, the fact finder. Now, in some circumstances, the parties will not have a jury. Either they agreed not to have a jury, or for some reason in this jurisdiction they're not entitled to a jury trial, in which case the judge will play the role of the law finder, which is the traditional role of the judge, and the judge will also play the role of fact finder, which is the traditional role of the jury. Throughout this unit, we're just going to refer to the jury as the fact finder. When there is extrinsic evidence, the evidence goes to the jury, and the jury then decides which interpretation is what the parties agreed to. All right, so let's talk about the different types of extrinsic evidence. We've talked about this before. Expert testimony, testimony by one of the parties, testimony by other witnesses, course of performance, course of dealing, and usage of trade. And probably the most important one for this is parole evidence. That's where the parties have a written contract, but before that they entered into some sort of oral agreement or some sort of written agreement, something that's written down that somehow, for some reason, didn't make it into the written contract. We'll talk about that in depth. All right, let's continue our discussion of interpretation by talking about the policy behind the two important rules. So there are two important rules on interpretation. They both answer the same question. Should we let the jury hear the evidence, right? We have extrinsic evidence. One party or the other party or both parties are submitting extrinsic evidence for the jury to hear that supports their respective interpretations. Should we let the jury hear the evidence? The judge acts as a gatekeeper. The judge will apply these two rules to determine whether we should let the jury hear the evidence. And this is important because a jury trial is expensive. If we can save society and the parties the cost of a trial, this is a good thing. All right, so the two rules are the plain meaning rule, we'll talk about that first, and then the parole evidence rule. Let's talk about the plain meaning rule. Here's the setup. So we have a written contract with an ambiguous term, whatever that term is. It could be a word, it could be a sentence, it could be a whole clause, it could be a provision, it could be the whole contract is ambiguous. Let's just think of it as an ambiguous term. The whole idea of the plain meaning rule is to determine, as I said, whether the jury should see the evidence, that the extrinsic evidence that one party is wanting to submit to the jury. If the written contract is not ambiguous, then we don't need any extrinsic evidence to explain the written contract. And then we can avoid a trial. We don't need a jury. So here's just a very silly example. House painter, we have a written contract and it says, house painter shall paint the house eggshell white. Right? And what does the house painter do? The house painter paints the house blue. Would we allow the house painter to submit evidence to explain that eggshell white really means blue? And the answer is no. Now, is it possible that the parties put down eggshell white, and when they put that down, they meant blue. They were thinking of blue. Yes, it is possible, but it is so unlikely that it's not worth us having a trial. The costs of having a trial outweigh the benefit of getting this particular case right. 99 out of 100 times when the parties write eggshell white, they mean eggshell white and they don't mean blue. For that one time, or maybe it's less than one time, where they meant blue, eggshell white to them is a shade of blue, we're going to get it wrong. But in that case, getting it wrong is not as costly as having a trial for all 100 cases. All right, let's look at the plain meaning rule. If a term in a written contract has a plain meaning, and plain meaning means it's not ambiguous, the term should be given the effect of its plain meaning without resort to extrinsic evidence. What is the translation of this rule? Well, the translation is the judge should not admit any extrinsic evidence to aid the jury in interpreting a term if the term in the contract doesn't need an explanation. If a term in a contract is ambiguous, admit extrinsic evidence to explain the term. If it's not ambiguous, don't admit extrinsic evidence to explain the term. It will throw the jury off, and if we don't admit any extrinsic evidence, we don't need a trial, and the judge can interpret the contract using the language of the contract. The judge can construe the contract. All right, continuing on, let's look at the application of the plain meaning rule. How does a judge know if a term in a contract is ambiguous? Remember, the whole idea is that the judge is acting as a gatekeeper. The judge will apply the plain meaning rule to decide whether this extrinsic evidence should go to the jury or not. So it's important for the judge to have some sort of standard to say, yes, this term in the written contract is ambiguous, so we will admit the extrinsic evidence, or for the judge to say, no, this term in the written contract is not ambiguous, and therefore we should not submit the evidence to the jury. How do you know that something is ambiguous or not? Well, experience, right? There are just certain things that we all know are ambiguous without any type of explanation. There are other things that are not ambiguous until someone explains the ambiguity to us. Let's look at a couple of examples of this. All right, let's practice applying the plain meaning rule. Imagine you are a judge and the written contract between homeowner and house painter says the following. House painter shall paint the interior of the house using premium blue paint. So let's imagine there is some sort of dispute between the homeowner and house painter, and let's say the first dispute is about the word blue. Homeowner wants to give testimony that house painter used the wrong blue. Well, blue is clearly ambiguous. Experience tells us there are many different possible meanings of blue. There's navy blue, there's sky blue, there's cornflower blue. So there's many different types of blue. Blue is ambiguous. So if homeowner wants to give testimony of the meaning of the word blue, we will let homeowner do that. Interior. What if the parties want to give extrinsic evidence about the meaning of the word interior? So for example, homeowner says interior means the unfinished cellar. And the house painter didn't paint the unfinished cellar. Would you let homeowner give this testimony to the jury, this extrinsic evidence, explaining the word interior? Well, interior at first blush might seem unambiguous, but after you hear homeowner's interpretation, you might say, yeah, I can see that. So the word interior is reasonably susceptible to homeowner's interpretation. We would let homeowner give that testimony to the jury under the plain meaning rule. What about the verb paint? Seems unambiguous, but what if one of the parties wanted to explain what the word paint means. Maybe there's something about house painting that I don't know. I, as the judge, do not know. And so once again, we'd have to hear, the judge would have to hear what the interpretation is and then determine whether the written contract, the written word paint, is reasonably susceptible to that party's interpretation. If it is, then you would admit the evidence to the jury. Finally, what about the word premium? Premium blue paint. Well, premium is vague. It's not ambiguous. And usually the plain meaning rule applies to ambiguous terms and not vague terms. So vague is a different issue. It's not subject to the the plain meaning rule, nor does it have a plain meaning. All right, let's talk about the different possible approaches a judge might take in applying the plain meaning rule. Remember, the judge is acting as the gatekeeper, and the judge asks herself, is this term in the contract that the parties are arguing over have a plain meaning? If it does, if it has a plain meaning, in other words, if it's not ambiguous, I'm not going to let one of the parties or both of them submit evidence to explain it. It doesn't need an explanation. It has a plain meaning. So there are two different approaches. First, let's talk about what I consider to be the minority approach. It's a very conservative approach. When the judge is considering whether the contract term is ambiguous, the judge relies on the judge's experience. Experience tells her what is ambiguous, and that judge will only look at the four corners of the contract. The judge will look at the term in the contract and look at the contract altogether and say, yes, this is ambiguous based on what I understand to be ambiguous, or no, this is not ambiguous based on what I understand to be ambiguous. I will not look at the extrinsic evidence that the party wants to, and I will not ask them to explain why this is ambiguous. I won't look at the circumstances. I won't look at anything except the four corners of the document. It's a very narrow approach. I think it's a minority approach. I think more courts will adopt the liberal approach. So let's talk about the liberal approach. All right, so the liberal approach. Remember, the question we're answering is, does this contract term, does this term in the written contract have a plain meaning? Is it ambiguous or not? If it has a plain meaning, it's not ambiguous, and we don't need extrinsic evidence to explain it. How will the judge determine whether it is ambiguous? Well, we talked about this idea that you don't know that something is ambiguous sometimes until someone explains the ambiguity to you. And you look at the surrounding circumstances and you say, oh, yeah, I see how that could be ambiguous. Okay, so what is the test here? Well, this is, I call it the liberal test. You can maybe call it the Trainer test. It's very associated with a judge, Judge Trainer, and he was a proponent of this test. So if you call it the liberal test or the Trainer test, either is fine. And the test is, after examining the extrinsic evidence and the surrounding circumstances, the judge gets to look at the extrinsic evidence and the surrounding circumstances as well as the actual written contract to determine whether the contract is ambiguous. After examining all of that, if the judge decides that the contract, the written contract, is reasonably susceptible to that party's interpretation, then the judge should allow the extrinsic evidence. Why? Because the judge is effectively saying, yes, this contract is ambiguous. Just looking at it without hearing your explanation, I wouldn't have thought it was ambiguous. But after you show me the evidence and you show me the surrounding circumstances, now I look at this and say, that is ambiguous. Go figure. If that's the case, then the judge should allow the jury to hear the extrinsic evidence. Now, here's an important thing. The jury can hear the extrinsic evidence, but the jury is free to say, we don't believe it. We don't believe it. So The admission of the evidence is an important battle that the party has won. I want to admit this extrinsic evidence to support my interpretation. Please admit it to the jury. We go through the the plain meaning rule, and the judge says, yes, let's admit it to the jury. When the jury hears it, the jury is the fact finder. The jury can say, we're not going to give a lot of weight to this evidence, or we don't believe it. So it doesn't win the war, it just wins the battle for that party.